Go now to the Money Desk. Devin Morrigan joining us. And Devin, you're talking about cheap imports and under-invoicing. It's got to do with that recent victory by the tax authority. And it's an important issue because, of course, if you under-invoice, you say, oh, well, I'm only bringing in 10 pairs of jeans, when in fact you're bringing in 10,000.
Yeah, and you declare different value. And I need not tell you the consequences of that goes through local manufacturers and to the fiscus as well. But you're quite right. Let's start right there. That recent court victory by SARS when it seized containers. This was back in 2020, yes. So it won a court victory in the Supreme Court of Appeals. SARS confiscated the goods imported by clearing agent Dragon Freight and 6 other importers on the basis that they had been clearly under-invoiced. It was a significant ruling, and as we said, impacts on the local economy in many ways. Retired Judge Dennis Davis, who is an advisor to SARS, certainly believes so. He joins us now. Judge, thanks indeed for talking to us. So before we get into this particular case, cheap imports and under-invoicing is not new. What damage has it done historically?
Well, it's done a lot of damage, because you just take the impact of any of these cases, and there are many obviously that have occurred, where because perhaps our customs system was not as vigilant as it should have been, and I'm referring obviously to an earlier period before Commissioner Kisvetter took over, and we all know what we're talking about thanks to the Nugent report. The point was that goods would be brought in at some ridiculous price, ultimately therefore circumventing customs, circumventing the idea that any of these goods, as it were, would come in at a price which ultimately would allow the local manufacturing to operate on an equal playing field. It eviscerates local manufacturing. It basically erodes the tax base, and people then get money out by way of a technique of transfer pricing, which I'm happy to explain, but which basically means that they pay no customs and they pay no income tax.
And Judge, I would imagine that is why that SARS victory in court is such a significant one. I mean, presumably it doesn't change the law, but it does set some sort of a precedent of some sort, I would imagine?
Yes, you see, the point about it was that these manufacturers, as Dragon Freight, I think they're a clearing agent together with various importers, won a case before the High Court. In other words, they managed to get the SARS decision to seize the 19 containers. They managed to get that set aside. If that judgment had been upheld by the Supreme Court of Appeal, it would have effectively eviscerated SARS's capacity to do precisely what I think it's doing, which is to say, sorry, you know, when you bring goods into South Africa, you are subject to a proper customs regime. And if you don't do that, you do so at your peril, because the goods will ultimately be confiscated. Now, the judgment of the High Court opened up the possibility of even more wide-ranging exploitation of the system. So although the Supreme Court of Appeal didn't assert any new law, the factual foundation and its reasoning was absolutely essential to the continued vigilance which SARS are exercising over illegal imports, yes.
And then it revolves around this entire issue of ethics at the end of the day. I mean, you ask yourself, at what point does tax avoidance become tax evasion? I'm wondering how you assess, the damage of both, because some companies may very well feel more ethically sound than others.
Well, okay, I mean, I've been on the other side as well before I became a judge, so I know the the operation of giving advice to taxpayers. But it's pretty clear that to give advice to taxpayers in terms of the law, people are entitled to minimize their tax liability within the confines of the law. What they're not allowed to do, and what their advisor should not be advising them to do, is one, break the law, or ultimately perpetrate schemes which frankly are nothing more than fraudulent, or at least any reasonable person looking at that would have to say, sorry, this cannot be kosher in any fashion at all. And why I ended my article, which is what you're referring to, with this question of having a conversation, because it's not just in the customs sphere. We are finding all over the place sort of very sophisticated tax advisors basically conceiving of tax schemes which erode the tax base and which, quite frankly, have no basis in law. But they're making a hell of a lot of money on it, and therefore it's probably worth the chance to market the schemes. So we should be having a national debate about what, in fact, a genuine, decent tax advice is, which does legitimately minimize tax liability, and the sort of thing which found in this case, which, quite frankly, as the Supreme Court of Appeal said, had no basis in reality. There's no way that the clothing that came in could have been justified upon the prices that ultimately were set to be the ones upon which customs should have been paid. I mean, no one could possibly have believed that, and the Supreme Court of Appeal, thank goodness, exactly wasn't going to be fooled by this nonsense.
And as I end it there, Judge, I mean, a lot of aspiration on that front. It's got to do with policing on the side of SARS as well. You've got to have the resources to do this kind of thing.
Well, we have to have the resources, and frankly, there should be a great deal of debate about ethical tax advice.
Yep. All right, we're going to leave it there. Judge Dennis Davis, retired Judge Dennis Davis, their advisor to the SARS Commission as well. Thanks very much indeed for talking to us.